SJC-12364, Commonwealth v. Michael J. Walters.
Mr. Stiles, good morning.
Good morning, Chief Justice and Justices. Ethan Stiles, appearing on behalf of Mr. Walters today. And we have returned to the court because the trial court's resentencing in this case, after this court had reversed Mr. Walters' stalking conviction, did not comport with his reasonable expectations of finality in the original sentence. In a sense, we believe that the judge, without justification, essentially retconned his
what was the word you used?
Retcon, essentially.
Okay.
Retroactively redetermined his sentence based on her feelings, not in 2012, when his original sentence was made, but in 2015, after he had reversed his conviction. And ultimately, the default rule was laid out in Brown, where it says that where a from and after sentence follows a sentence that becomes invalid, then that from and after sentence starts on the day it was imposed. And that's been the case, and that's been the default rule for almost 60 years.
So let's play this out, if we could, for a moment. So the stalking case is vacated on appeal. Now, the House of Correction sentences were not from and after the perjury.
No.
So, therefore, the stalking sentence doesn't exist. You can't say that the perjury has to be from and after the House of Correction sentences. So the perjury sentence, you are saying, should have been imposed on the sentencing date of June 12th, whatever year it is.
Yes, that is
And if that had been the case, then he would have been parole eligible or wrapped up, indeed, earlier than he otherwise did based on the resentencing. Is that right?
That is correct.
Okay.
Justice Lowy. Now, the structure of the sentence, we must focus on that. And the structure says stalking, I'm not sure if the numbers might be wrong, but say count 1, stalking, 3 to 4 years. Count 2, criminal harassment. 2 to 3 years concurrent with, 2.5, it's a misdemeanor. 2.5 years concurrent with count number 1. 209A, restraining order violation. 2.5 years concurrent with numbers 1 and 2. Perjury. 2 to 3 years state prison concurrent with number 1, and that's how it reads. And there's no issue about that.
And from and after the stalking that no longer exists.
From and after
so
stalking
the perjury has to be nunc pro tunc back to the sentencing.
That is what we argue. Now, and the Commonwealth says, well, the Brown issue was only to avoid dead time, and he got credit for the time that he served. But there's more than Brown than just dead time. And but first, there's the dead time that, if that was the way it was supposed to work, was that nunc pro tunc thing was supposed to happen, then anything after, then that's June of 2012, I believe. So June 2015, 3 years have passed, he must be released. So anything after that, now we're dealing with issues of dead time. But there's more to Brown than just that. Brown, I think, stands for the point that the court should try to avoid ambiguity in sentencing wherever possible, so that defendants don't have to face the uncertainty of what's going to happen to them when they go back, because now they've achieved some sort of a success at the appellate level. And by applying Brown as it stands, that is accomplished. The defendant knows that, okay, 2 to 3 years, I can demand release immediately, and I don't have to get to the part about the judge's discretion on resentencing, where I can show him all the good things I've done in prison, and the Commonwealth can try and show all the bad things he did in prison, or whatever they want to do. Because at that point, then you're dealing with the judge's discretion, and he can raise or lower it. If you apply simply based on the sentence that was written, then you get the best relief, and the relief that you expected, and that you've been working for this entire time on the appeal. Now, the judge in this case could have done something different. She could have staged the sentences appropriately by adding a few words to the statute. She could have said, instead of perjury on and after count 1, she could have said perjury on and after all previous instances of incarceration, or words to that effect, and essentially made a 3-stage sentence where you have sentence 1, it consists of criminal harassment, stalking, and 209A. Stage 2, from and after all stage 1 consists of perjury. And stage 3, which is the probationary sentences for perjury and 209A, occur after all incarceration. So in that sense, then you have a clear and structured sentence, and the defendant knows, okay, I know that it's going to be 2.5 years plus 2 to 3 for perjury. Now let me go and push my discretion to ask for less.
To be that,
I'm sorry, just in general, does a judge have discretion to sentence to the House of Correction from and after the state prison sentence?
Does the judge have discretion to sentence from and after a state prison sentence?
To the House of Correction from and after state prison? I mean, usually people sentence to the House of State Prison first, and then they...
Yes, I want to make sure I
in
understood.
this case, perhaps not. So did Judge Garsh have that discretion to sentence from and after?
And see, that's a troubling aspect of the retcon here, is because that does end up with the effect of, essentially, because Mr. Walters was always in state prison, notwithstanding anything my brother said.
Did Judge Garsh have that discretion?
I would suggest it's a questionable discretion at best, because ultimately you're not graduating the punishments in a rational
What is
way.
questionable discretion? I was a trial judge, and I probably had this questionable discretion too, but what does that mean?
I would suggest that it is an issue where if the judge, I'm not sure this court has decided that, so I would think ultimately that might be an issue for another day, that where there is an event like that, then that might run afoul issues of rationality, as I said, because usually
Don't you think that would have come, I mean, unlike the 3 trial judges sitting here, I haven't done this, but wouldn't that have come up about 10,000 times? I assume we've got those kinds of sentences out there all the time.
Yes, and I think that's one of the reasons why this court should not dismiss this case as being moot, is because you will come up with these sort of sentences. We have short sentences, 2.5 years, 2 to 3 years, come up, and the appellate process can take a while. In this case, it took roughly about just over 3 years to get from sentence to overturning. So essentially, you will have an issue
Are
where...
you going to pass on my question, or are you going to answer it?
No. You see, Justice Gaziano, the difficulty of your question is that, I want to say no to it, because essentially at that point, you have an issue where the sentence doesn't look very rational, because the punishments go from house to state to probation. It doesn't work as a rational understanding. But on the other hand, I must acknowledge that until that strong conviction is overturned, there is no problem with the sentence. I mean, it ultimately is the result. But I think where you have this situation...
So your answer is just standing alone, not this case. If a judge decided to sentence in that fashion, with a state prison session from and after, you would think there'd be no rational basis, and we should tell judges you can't do that.
I don't think you need to. I'm not sure if you need to go that approach, but I think in another case where the facts were simpler, unless it was a situation where the charges were unrelated. If the charges were unrelated, then obviously the judge can do what he wants. But if the charges are related, then there would be a serious issue whether that would comport with due process.
see, going back to Justice Gaziano's point and just trying to simplify this, there's all sorts of reasons why a trial judge would have the perjury conviction be from and after whatever sentence is imposed. But here, which I think inures to your client's benefit, here the perjury sentence is not from and after the House of Correction sentence. It could have been, but it wasn't.
Yep.
And so since it wasn't from and after the House of Correction sentence, it had to start on the original sentence date.
Yes, I would suggest that is the case. I mean, otherwise, then you get to the issue that Mr. Walters has been saying all along, is that ultimately, if you go the trial judge's route, you endorse something that the legislature does not provide, which is namely a House of Correction sentence being, state prison sentences being served for misdemeanors, and that is one approach you take, is you put the perjury charge first, and you don't have to deal with that. And that's one thing this original sentence does, is that if you apply it as it's written, then the House Correction sentence, 2 to 3 years, and 2.5 years served concurrently, there's no more issue, because that 2 to 3 years will always swallow up the 2.5 years due to the way that parole is implemented. So, unless the judge, I would suggest, is clear in this case that she viewed that perjury charge was its own animal and not part of the course of conduct, then perhaps the Commonwealth and the judge might have a point that this is what I meant to do back in 2015, instead, or 2016.
But that is what she might have meant to do. She might have meant to say, okay, I want the perjury charge to be from and after whatever other sentence on the underlying crime is served. I want it to be after the House of Correction sentence, after the stalking sentence. And that would make perfect sense. But that's not what happened.
No. And ultimately, if the judge, suffered from a lack of foresight in that she expected that this sentence would play out as she originally intended, then she wouldn't have an issue. But and perhaps she could have by being clear in her either her sentencing remarks or the actual sentence as she wrote, that this is what she wanted to occur.
So if at resentencing she had said, well, my intention was to have the perjury charge because that just exacerbates everything. That's a whole different concern. Mm-hmm. My intention was to have it from and after whatever underlying sentence was. The stalking is no longer here, so I want it from and after the House of Correction sentence. You would say it would be a different case.
No, well, actually, that's what she did. Because that's what she ultimately did say. I think the Commonwealth cited in her memorandum, and I think she also stated that on the resentencing date.
Why isn't that okay? I mean, that's one. You didn't really quite answer Judge Lowy's earlier question, but why does it have to be nunc-pro-tunc? Why couldn't she just shift it around as she did? Why is that improper?
Well, I would suggest that the court's recent decisions, such as Solip and Perillo, prevent her from doing that. Essentially, because those sentences have been served. 2.5 years, 2 or 3 years. By the time he got relief from this court, those sentences have been served, and so she can't do anything with those things anymore. Those are dead issues as far as this court's jurisprudence is concerned. So, but if we go back and if she said something like that in 2000, but see, there's the issue that there is nothing in the 2012 record that suggests that she saw the perjury charge as any sort of special animal. Now, perjury is not under Chapter 265, as most of these other offenses are, crimes against a person. It's under Chapter 268, which is crime against public justice. There's not one word in 2012 about his effect on the judicial system and that sort of thing. Essentially, the perjury charge all was part of the conduct that all related out of the victim. It was all about the victim in 2012. Now in 2015, she wants to say, this is part of the victim, and this part was public justice. That's not right. And essentially, comes too close to Commonwealth versus Coleman, which essentially prohibits a judge from revisiting her sentence.
Presently, when does he finish his probationary term?
Yes, I was going to discuss that when I got to the issue of mootness.
Well, you have 2 minutes left, so you're
right,
getting to the question. Why don't you try my question?
All right,
when does his probationary term end?
All right, so Mr. Walters was released on December 7th, 2016. He has a 5-year probationary sentence. One is straight probation, one is 2.5 suspended with 5 years. So essentially that means he finishes his probation in 2021.
Okay,
now,
and if we agree with you, when does his probation end?
Well, his probation was due to end after all incarceration. So if all incarceration was supposed to end, for example, say this resentencing date, which was December 11, 2015, it ends then. Or if the date is the date that the court issued its rescript, that would be September 18, 2015. Or if you want to go back to adding in the good time, that would be an even earlier date. So essentially, that's one issue why it's not moved. Now, I think the other issue I already touched upon, namely that the issue can arise again, that they were delayed, that this case.
But what's the earliest date at which his probation would end if you prevail?
I would suggest that, not accounting for good time, because I don't have the number. I think it's in the brief, and I don't want to confuse the issue. The earliest date that he should be eligible for that. If we do by calendar year, then the earliest date that that would be June of 2015. So So 5 years would do in 2020. So there's at least a year less of probation that he would have to serve. And also, the other two reasons, before my time is up, is the evading review, especially in a case where this case was a little longer than a typical appeals case where you had a lengthy transcript, you had a change of counsel, you had taking up on sua sponte by this court, and also the waiver of the 130-day rule. And the final thing, and I will, if you allow me, is the last thing, of course, is the wrongful conviction statute, which if he has more than a year attributable solely to this stalking conviction, he can apply for relief. Whether he gets relief, that's not this court to say, but at least this court, if it says, yes, you served more time than you should, Mr. Walters, more than a year, then he can go and apply for relief. But he can't unless this court actually says that. So I think for those three reasons, this case is not moot and deserves a full opinion from this court. And with that, thank you for your time.
Thank you. Mr. Michel, welcome back. Question.
Good
just
morning.
with
Roger
regard to the
Michael
issue-
again for the
with
Commonwealth.
with regard to the issue of mootness, if your brother is right and there's a year difference in terms of when the probation would end, why is it moot?
The appeals court found the case to be moot and dismissed it on that basis. There is some, I think, disagreement between me and my brother about the sentencing calculations. Rather than make a representation to you here today, because good time is difficult to calculate on the fly, I would be very happy to submit a letter reflecting my calculations.
But I guess more generically, if indeed, put aside whether he's right, okay?
Yes.
But if he makes an argument that says, if I am right, my probation will end a year earlier than it otherwise would, why would that, how could the case be deemed moot?
If that turns out to be the case, Your Honor, then I absolutely agree the case is not moot. But I would like the opportunity to share with you my sentencing calculations.
Okay, well, I mean, but would you be your calculations even if he were right? Because
It does depend on the precise nature of the disposition
he may not be
here.
right, but
Yes.
but that's not the issue of mootness. The issue of mootness is
I agree.
if he were right, would it matter?
Absolutely, I agree.
Okay.
However, having said all that, to me, as several of you said this morning, this is simply a matter of judicial sentencing discretion. I don't see my brother having identified a single instance in which the judge here, a very experienced trial judge, made any mistake or overstepped her discretion in any area. In her mind, and she put this on the record, as my brother indicated at the resentencing hearing, the perjury charge related to a different quality of conduct, a different kind of criminal conduct, and she wanted to have it from and after the other sentences for the assaultive behavior, stalking, the 209A, et cetera.
What do you say to your brother's argument that at the first sentencing hearing, she did not mention that, but at the second sentencing hearing, she did?
Well, what I would say to that is that it was implicit in the sentence structure that she was treating it differently. She pulled it out from the other charges, made it from and after. I agree with you, it would have been better for the Commonwealth had she put that on the record the first time, but certainly her actions were consistent. The sentence structure was consistent as to both the original sentencing and the resentencing. She explained her actions in a way that was not only reasonable with respect to the resentencing, but also appeared to be reasonable and consistent with what she had done the first time. So I would suggest to you there's no reason to think there's any inconsistency in her reasoning at the two sentencing hearings. As far as the argument that my brother makes relating to where one has a right to serve his or her sentence, the statute's pretty clear. The commissioner has the authority to put you where the commissioner wants to, but I don't think that's really where the gravamen of the dispute should lie. The reality here is that at the time he was serving that sentence for stalking, it was a valid sentence subject to being reviewed on appeal and possibly being set aside, but the case law is pretty clear on this, and I've cited the relevant authorities. When a person is confined in accordance with a duly imposed sentence, that confinement is lawful until the conviction or the sentencing process that led to it is reversed through the legal process, and that's DuPont. And that's exactly the situation here. It may have been the case that he shouldn't have been serving the House of Correction sentence in a state prison, but the reality was, at the time he was serving it, he wasn't serving a House of Correction sentence. He was serving a state prison sentence. And so there was never a problem with the place of confinement. There was no issue of abuse of discretion here. The judge did something which is completely rational, which she explained on the record, which she is fully empowered by law to do. I just don't see what the issue is here.
And do you want to take a shot at Justice Gaziano's question?
Can you reformulate it for me?
The question was, does the judge have the discretion to give someone a from and after sentence to the state prison from and after a House of Correction sentence?
I have some practical experience in this area, Your Honor, and I can tell you that I have seen instances of folks serving such sentences. I don't see anything in the statute which would disable a judge from doing that. Frankly, as I say in my brief in this case, there were lots of good reasons, separate and apart from her intentions with respect to the sentencing, i.e. to cull out the perjury charge and treat it differently as a from and after sentence. There are issues of continuity of treatment. There are all kinds of reasons why the judge might have wanted him to continue at that same place of confinement. The reality is that there are factors, and this is not part of the record, but I'll merely say that one can take notice of the fact that there are different programming opportunities at different houses of correction around the state, and the judge may have taken into account the kind of programming that was available at local houses of correction in the jurisdiction in which he was tried. But in any event, there are lots of things. This is all by way of saying there are lots of things that factor into judicial discretion in this regard, and it's why trial judges are accorded broad discretion to make these choices. Absolutely yes to your question, and there's nothing that says that a judge can't do that. Tocqueville said, don't confuse the familiar with the necessary. I agree with you that the reverse is more typical, but that doesn't mean that it's unlawful to do what she did. And she didn't really do it in reality. She was a state prison sentence followed by a state prison sentence. It's only if we accept the fiction of what she created by way of resentencing as if it really happened that we run into a problem. It didn't really happen that way. What happened in reality was he served a state prison sentence followed by another state prison sentence. He was always placed in the same institution. So that's the reality. I agree with you. Were we in a different case where a judge had, for whatever reason, given a House of Correction sentence to be followed from and after by a state prison sentence, there's no reason the judge can't do that, but that in reality is not what we're dealing with here by any means.
All right,
If there are no further questions, thank you.